Okay, first of all, I would like to apologize for the technology gremlins we experienced in our last webinar. We'll do this, you're now watching our recording, and I want to thank you for listening to this webinar. Over the next 1 hour, we're going to be discussing business practices, the rules, the standards. We have some examples of some bad business practices we're becoming acutely aware of. And we'll also talk about how you can stay off the radar of the investigators. So poor business practices is negatively impacting the physiotherapy profession, and it's also impacting the trust that the patients have with their physiotherapists. Now, I know most physiotherapists provide good quality and exemplary care, but there's a few physiotherapists being involved in bad business practices that are really tarnishing our reputation. So it's so important we have this discussion today. My name is Fiona Campbell. I'm the Senior Physiotherapist Advisor here at the college. I'm joined by Allan Mak, who's our Manager of Investigations at the college, and also Richelle Feddema, who's the Chair of the Anti-Fraud Working Group at the Canadian Life Health Insurance Association. And thank you for joining us. So I'm going to start off. I'm talking about the standard for fees, billing, and accounts. The first section of that standard we have to put out front is the physiotherapist is accountable for their registration number when it's used for billing purposes or for used in accounts. That means you can't transfer that accountability to the employer, to the person on the front desk. You need to have a system in place to check the accuracy of any billing done. You need to have a written policy. You may work in a large organization, you may work in a very small clinic, but there must be a process where you're getting lists of the invoices that are made with your registration number, and you're going through a process to check what was charged, what service was described on the invoice, and check that with the patient record with your own files as well. It might be you check all of the invoices. It might be that you only check a small sample of invoices, but you must keep a written record of that check, whether you're doing it once a week, once a month, record that. You may be asked for evidence you've done that check by the college or by other investigators. So I told you have to do an audit. You have to ensure that there's an accuracy check in place. If you have any difficulties or struggle with that, we do have samples of audits here at the college. We've posted that on the college website. We can share that with you. Our advice team can also, you just call our number and we can talk through how that might be done. Fees, schedule and communication of fees. So a physiotherapist, a clinic must have a published record of their fees for any services, whether it's assessment, whether it's for a treatment, whether it's for any administrative tasks, like patients who ask for a photocopy of their patient record. Yes, they're entitled to that. Yes, you can charge a nominal fee to make that photocopy, but you must have all of these fees recorded. Now you could do that on your website if the clinic or your organization has a website. You might post your fees there. It might be a brochure. It might be a script that the front desk administrator goes over with the patients. Your job as a physiotherapist must be to be confident or ensure that the patient understands what the charges that will be made for their service, for their physio assessment, their treatment, or for any administration task. You need to be confident they know, they understand, and they've agreed to those charges before you provide the service. Now, when you post your fees, you can post them for each of your funding stream, make it clear, make it transparent to the public exactly what you're charging. If you want to deviate at all from that posted fee, you can come down in your charges, but you can't go higher than the charge. Fees for packages of service. I put the slide up. This is the last section of our standard. Many people ask, can they offer a fee for packages of physiotherapy services to their patients? The answer is yes, yes you can, but it has to be for a specific patient's condition. the patient has to be offered an option of purchasing individual treatments rather than a package of care. They also, if they don't use all of the sessions in that package, they can also be offered a refund for those services. So yes, you can, Groupons, etc. are permitted at this college. Now that's the last section of the rules. And now I'm going to turn over to Allan Mak, who's our Manager of Investigations. He's going to talk a little bit about some of the bad business practices that we have become aware of. Allan.
Right. Thanks, Fiona. That was a great overview of the standards and expectations. Our college, we receive quite a number of matters in dealing with fraud, and I'm going to go over some of the common issues that have come across in regards to fitness programs and gyms, and then we'll go over a particular case that went to discipline and ultimately resolved. So what we've seen commonly, and that's been quite prevalent, is that PTs or physiotherapists some often or sometimes get into arrangements or relationships with a fitness program or a gym, and usually in some of these cases, for instance, they would uh, be required to um, attend the fitness facility intermittently or sort of on rare occasions, whether it's once a week, once every couple of weeks, and whatnot. And what they would be asked to do by their employer is to conduct an initial assessment and then, prepare a treatment plan. And then what would ultimately would be that patient and that case would be assigned to a personal trainer or a PTA. And then the patient is advised that they're able to utilize their benefits and say that their fitness programs can be used or claimed under their personal group benefits and whatnot, and or perhaps gym membership. So obviously, this is a bit of an issue. So in most cases, these clinic owners are not owned by physiotherapists. They're sort of non-healthcare practitioners, so there are really business individuals. They're not aware of the standards and what the expectations are, and us as a regulatory body, we don't have any oversight over these PT or non-PT clinic owners. So, what do we do from our perspective in terms of the college oversight, and what do we look for from and expectations from our physiotherapists? So, when we do sort of investigate these matters, we look at whether or not um, there was appropriate treatment. We look at proper assessment. We look at diagnosis, and then we sort of look at in terms of if the notes in terms if there's any progress or any reassessments and follow-ups with a patient. We also look at sort of if there's proper supervision um, uh, with the PT and follow up with the patient. So really, if they are assessing whether or not the PT has the proper knowledge, skills, and judgment, and if they're confident in carrying out the treatment program that has been sort of assigned by the PT. We also look at whether or not there's fraudulent billing. So we look at whether there's false claims, whether there's proper invoicing and whatnot. And then, and finally, we'll look at record keeping if the records are complete and whether they are accurate. So, uh, next slide, please, Fiona. So we look at a particular decision that came down in April 2019 from our discipline committee. There was a particular PT that was working with a facility that was located in a complex with a gym and arena. And this clinic was offering chiropractic, massage therapy, and physiotherapy services. So they did have those practitioners available there. The gym was operated separately from and independently from the particular clinic. And then the gym employees were also employed by the gym and not the clinic. So we received a public complaint saying that the physiotherapist at the clinic was referring patients to the gym that was adjacent to the clinic, and they were getting personal training services. They were being invoiced, they were claiming invoices that were for supervised physiotherapy. So that caught our attention. So what we did, um, next slide, please, Fiona, is that we conducted an investigation. Um, and first of all, what we did was send in an undercover appointment investigator. So the investigator posed to be a patient. She indicated she had no pain, she had no weakness or injury or any specific conditions or any primary concerns. What she was there for was specifically was for weight loss. So the PT, the physiotherapist, conducted an assessment, and what they derived was the undercover investigator patient had identified muscle weakness, and the core and right gluteus muscles were recommended for a supervised exercise program at the gym. And then also the PT advised the investigator that invoices could be claimed through insurance benefits and whatnot. Secondly, what we did after that undercover appointment, we sent in another investigator on a separate date to, first of all, go in and collect records of 9 random patients. And then secondly was to interview the gym staff that was associated with the clinic. So what was uncovered from the interview with the gym employees was that the PT did not assign any patients to the specific gym employee. So the PT was not aware who was handling care for each of these patients. So there was an assessment of whether or not these gym employees or personal trainers had the knowledge, skills, and judgment to perform these exercises. Also, it was also uncovered that the specific exercises, they were determined by the gym employees in terms of frequency and intensity of the exercises. So that wasn't determined by uh, the physiotherapist. And then there was no follow up after the fact with the PT and the patient, or with the patient and the PT. So there was no reassessment and whatnot. So there was concern of whether there was progress for the patient and whether or not there proper supervision and things like that. And then also in the records, there was no SOAP notes, there was no objective information, there was treatment notes, there was no treatment notes, and then all that was contained within the records was the information that was recorded in terms of exercise and what the exercise programs were identified by the personal trainers, the PTAs at the gym. So in terms of findings, the records, again, they matched in terms of what was identified in the interviews with the gym staff. Again, it was the assistants or the personal trainers that were assigning the exercise and the treatment plans and whatnot. They were carried out by them. They were doing reassessments and whatnot, and it wasn't the PT, and then they were documenting all this information in the records. And so it wasn't the physiotherapist. In terms of billing and false information, there were 23 treatments under a specific patient where they were getting chiropractic treatments. They were getting spinal manipulations, and this particular physiotherapist was not rostered to conduct spinal manipulations. So again, that was fraudulent on the PT's perspective. In terms of record keeping, sorry, just going back there, Fiona. Again, it also matched with the interview with the gym staff that the records were not consistent, and they did not have the SOAP notes, and also was only had information about the exercises recorded by the gym staff. So moving on, so this matter was referred onto the next slide, please, Fiona. This matter was referred to the discipline committee. They did find a breach of misconduct. This individual was reprimanded and was asked to appear before a panel of the discipline committee for a reprimand. They were suspended for 15 months with the opportunity to remit 9 of those months, as long as they completed um, an ethics program, and then also a review of the standards for fees and billing, supervision of PTAs, and record keeping. In terms of during that time of suspension, the PT was permitted to work as a PTA. However, they had to be supervised by a registered member of the college and had to be pre-approved by the college. This member also had to participate from a 2-year period in a practice enhancement program. Again, with some coaching, and then it would focus on, again, fees and billing, proper supervision with PTAs, and also record keeping. And also sort of at that time, as they're part of the practice enhancement program, they didn't have any privileges to supervise any students or any PTs at that during that period, and they were ordered to pay a cost of $5,000 for the cost of a hearing. Next slides, please. So lessons learned in terms of how to prevent from these types of situations for PTs especially is that it's a good idea to do your research when you're meeting with these clinic owners. Ask a lot of questions in terms of how their business operates. Ask colleagues within the field in terms of if they've heard the facility. If there's any suspicious activity going on, I would ask questions and trust your instincts. And then if you're not 100% confident and comfortable with the business arrangements, certainly don't sign up with that clinic. In terms of ownership of patients, you are accountable to the patient's care. So don't allow anybody to take ownership of that patient, whether it's the owner or the PT or any PTA or personal trainers. Again, you are accountable. So ensure that you do proper follow-up with the PTAs, with the patient, ensuring that there is progress and that the treatment is necessary, and if it continues to be necessary. And then also on invoices, just when you are working with your employers, ensure that there is a process in terms of where you can sign off on these invoices. Make sure that they're accurate and before they're submitted and claimed. And then if there are issues that that you are noticing in terms of billing and whatnot, our suggestion is to report that to the college, and also report that to the insurance companies that these things might be happening. Your registration number might be being used without your knowledge, and so it's good to report to college of these things occurring. So just one more key point that I'd like to point, the college takes these matters very seriously. There's very low tolerance in terms of this type of activity. And one way to sort of prevent a lot of this happening is to have proper record keeping, ensuring that it's very important to document, ensuring that all your correspondence, all your treatment notes are all properly recorded, obtaining consent and whatnot. And I do mention that is because when these investigations do occur and then they are being reviewed by the ICRC or discipline, they rely heavily on the paper trail and the records. So it's if it really tells a story when they do review the patient charts and whatnot. So it's a good idea to properly document and have the completeness of the records. Thanks.
Now, Allan, do you mind? But just before I turn over to you, Richelle, I just have one slide I did skip over because I think it's good to follow what you're saying, and that's the topic of delisting. We had many questions that came in before this webinar about delisting. Delisting is not a college process. However, we are aware that some insurers, not all, but some insurers are delisting physiotherapists and they're delisting clinics. That delisting means that they're removing costs that they will provide to fund for physiotherapy or patient care. Very upsetting to the physio or the clinic. I can imagine it's quite distressing. I can imagine the patient is also distressed. They're not being funded for physiotherapy care and they do have to seek services elsewhere. So our message to you is prevention. As a college, as a regulatory college, yes, we're aware it's going on. It's not our process, but our message to you is to prevent this happening. So really what Allan was saying, you really need to start looking at your charting. So ask yourself, are you documenting in each patient file? Do you have a firm diagnosis? Do you have a treatment plan? If you're assigning care to an assistant, a personal trainer who's working under your supervision, make sure you are fulfilling all the supervision requirements, maintain that therapeutic relationship with the patient and ongoing communication with the person you're assigning care to. I'd also suggest, to follow up Allan's point, you should have a conversation with your employer. Make sure that they understand how your registration number is going to be used for billing. And if you leave that clinic, I was just speaking to Richelle before the webinar, if you leave that clinic, put in writing that you do not you absolutely prohibit your registration number being used after a certain date. If you're suspicious, Richelle, you can follow up on this. If you're suspicious at all about what was happening in that clinic or that organization, you might want to be quite rigorous with your follow-up. I'm going to hand over to you, to Richelle. Is there anything you just add to that comment?
I'll speak a little bit about it later in my presentation, but there is a Fraud is Fraud. It's a national education awareness campaign that was launched. It's available for the public to be more aware of what benefit fraud is. And it also can be used for providers if you want to report any suspicious behavior. If you think anything's being used without your knowledge, you definitely can use that website. You can choose a specific insurer, or it can be a blast to all of the carriers. And the carriers do take these tips very seriously. They do investigate all matters right to the end. So that's a good avenue that you can take for that.
Thank you. So I'm now going to turn it over to your presentation.
Perfect. So thank you, both of you. I'd just like to thank the college for inviting me to participate in this webinar. And Allan's case study was super interesting. Unfortunately, it's not an isolated situation. It is becoming more and more prevalent. So I'll talk a little bit more about some trends that are happening, but first, I'm just going to start with a high-level overview of group insurance relating to health benefits and billing options for reimbursement. Then I'll discuss some of the trends that are emerging in the industry. So the plan sponsor is the employer. They make the decisions on what's covered and on what basis. So a plan design would determine the specific details of coverage, including things like the maximum, so the dollar amount that's eligible per benefit period. So an example would be $500 per calendar year. Co-insurance, which would be the percentage that's eligible for reimbursement, 70%, 80%, sometimes all the way up to 100%. Sometimes there may be a deductible in place. It could be a per patient, or it could be per family. In addition, maximums could have paramedical services combined to include an overall maximum. But the important thing is it's not the employees that are picking these plan designs, it's their employers. And even plan designs can vary from one employer to another that have the same insurance carrier, and even employees of the same organization may have different coverage depending on the plan structure, if there's union employees, management, etc. So for billing, there are typically three options that is available to collect for reimbursement. The first option would be providers submitting electronically to an insurance carrier. They'd be set up for assignment of benefits, and the payment would go directly to the provider. They may collect any difference that's not covered from their patient. Plan members, patients can submit claims in two ways. So if it's not submitted electronically by their provider, they can either mail that invoice along with a copy of the claim form to their insurance carrier, or they have the ability to submit electronically through their insurance carrier's website portal. So some fraudulent billing examples with some of these billing options would be, a clinic submitting a fake claim when no services were rendered, or also a plan member or patient submitting a fake claim. And I'll talk a little bit more in a little bit as to what the specific details are as to how that might happen. Next slide. So fraud is about deception. It's designed to go undetected. We don't have the numbers of the consequences of fraud to the life and health industry in Canada. We do know that it's costing in the hundreds of millions of dollars. So even if we indicate that fraud represents 1% of what's paid, the industry is paying approximately $34 billion a year. So 1% would equate to $340 million, which is a substantial amount of money lost to fraudulent activities. There are some sources that say that it could be as high as 10%. So I'm going to define the difference between benefit fraud and abuse. Sometimes the two terms can be misunderstood as to what the differences are. Benefit fraud is very obvious. It's a person submitting false information for financial gain. So essentially fake claims, claiming for services that were not rendered. Benefit abuse would be exploiting the plan. So healthcare providers that are performing unnecessary treatments to maximize billing, multiple family members, all receiving, the same care, maybe have the same treatment plan. Those would be some examples of what benefit abuse might be. Some of the types of fraud or fraud schemes that are trending in the industry right now, I've broken it down into kind of 4 different areas. The first one being plan member. So plan member submitting essentially fake claims. So how that would happen is a plan member may receive services from a physiotherapist. They receive an invoice for the treatment. However, that person may go on and submit additional claims where maybe services weren't rendered. The other thing that we're seeing is identity theft. So perhaps plan members are providing their benefit cards to family members or friends who do not have benefits and letting them use them. Providers selling credentials knowingly for profit or having their credentials used without their knowledge. So having their credentials used without their knowledge is more common. So an example would be a physiotherapist works in a new clinic, maybe works 1 or 2 different days, and they determine that the business practices are maybe not up to the standards of the college, and they decide to leave that clinic and go elsewhere. What happens is that clinic may continue submitting claims where no services were rendered after they've left. So some of the things Fiona and Allan have talked about is prevention and ways that you can protect your credentials. Merchandise in lieu of services, so claiming for services and in turn receiving things like designer purses, shoes, sunglasses, things of that nature. So service provider fraud is on the rise. We are seeing more and more multidisciplinary clinics. So they're a one-stop shop. Fraudsters are taking advantage of several providers and medical equipment at one location. Fake clinics. So what a fake clinic? Well, essentially from the title fake, there's no services being rendered at these locations. They may be using a location of a warehouse, a vacant lot. Malls are common, or high-rise buildings where there's multiple suites. In some situations, they may go as far as actually setting up a fake storefront where they may have signage indicating that business is actually taking place in that location. In other situations, they may even have a receptionist working there that's answering the phone. However, upon visiting that location, there's no medical equipment on site and there's no patients coming and going that are receiving care. Oh, sorry, just one more. The last thing there is collusion. So we're finding that these operations and schemes are becoming highly organized. They're very, very sophisticated. So collusion essentially is when 2 or more people collude together to plan out a fraud scheme. One of the most common that we see would be a 50-50 cash split. So essentially, no services are rendered, submitting claims for, let's say, physiotherapy services. When the provider or plan member receives reimbursement, they're splitting that profit 50-50. Sometimes there may be referral programs being offered. If one person is entered into this scheme, if you send some of your friends, you may get a kickback. So clinics also, we're seeing that if they're targeting a specific plan sponsor, so a specific employer, a high concentration of treatment being rendered by employees within that organization. So my next slide is going to talk about some real life examples of where these situations actually happen. And they actually happened right here in the GTA. I'm not sure if everyone may or may not be familiar with a couple of these cases. The first one there on the far left was the TTC. So that was very, very publicized. It involved mostly orthotic claims. As a result, there were 220 employees that were fired, lost their jobs, 120 arbitrations, 10 employees were actually criminally charged. It resulted in $5 million in exposure. And in this situation, the clinic was targeting one plan sponsor, which was the TTC employees. The next one is the Baycrest Hospital. So this alleged scheme involved one ringleader that was responsible for recruiting various employees within the organization. As a result of this scheme, there were 150 employees that were actually terminated, which represented 8% of the employees that worked for the hospital. So you can imagine the efforts to replace 8% of your staff. It was a multi-million-dollar organization, and it spanned many job categories all the way up to RNs. So the alleged fraud scheme, there were two types of fraud that were happening in this scheme. The first one was the classic 50-50 cash split that I talked about earlier. Again, submitting for services such as physiotherapy, no services being rendered using a provider's credential, and then splitting that profit. And then the other alleged fraud scheme was the sending in claims and having merchandise provided instead of services. So what can providers do to ensure protection? As Allan and Fiona have both alluded to some of the things that you can do, I've outlined 3 steps here. So step 1, don't give out your license or provider number to a clinic until after you've been hired with that clinic, signed any agreements. The second step is to make sure the clinic staff or the owner have an agreement as to what the appropriate use of your personal information is. And the third step is when you stop working at a clinic, have an agreement that no further invoices or claims can be made with your license after the date of your departure. So prevention through education, the Fraud Equals Fraud campaign was launched in 2018. So it was an industry initiative sponsored by the CLHIA with the support of its member companies. It's been very successful in educating the public on what benefit fraud is and what people can do about it. So recognize it when you see it, report it. The Fraud is Fraud website is on this slide. And as I was saying earlier, you can go to this website and there is a spot there where you can report fraud. You can report it to a specific insurance carrier or to all of the carriers that are listed. The CLHIA has some excellent reference documents on their website. So I've included 2 here that would probably be very beneficial. So the first is Service and Supply Provider Receipt Best Practices for Group Benefit Reimbursement. So that's a list of best practices to be used by medical service and supply providers when invoicing customers. These best practices have been developed by member companies of the CLHIA and are an important tool in ensuring valid claims are paid promptly. They also assist in reducing fraudulent activities and delays resulting from incomplete information. The second document is the Supplementary Health Insurance Explained for Healthcare Providers. So this document was created by 11 health provider associations who partnered with the CLHIA, including the Canadian Physiotherapy Association. And this document is intended to help healthcare providers and their patients understand the private health insurance environment.
Okay, thank you very much, Richelle. I know we've got some time left and we just want to address some of the questions that have been submitted. The first one, I obviously have to go to Allan. The question is, I work in a gym. Most of the patients I assess will work through their program with a personal trainer. Is this okay? Allan, can you take this one?
Thanks, Fiona. So my answer to this, it really depends. So if they're really using it for personal training or, as Richelle and Fiona mentioned previously, for other purposes, then no. the PT has to do a proper assessment with the patient. There has to be a proper diagnosis and scope within for the PT. There's got to be clinical reasoning to support the provision of the physiotherapy in terms of the exercise and the treatment that's being provided. So, and then the PT has to ensure that the whoever's providing the treatment or the exercise is fully competent to provide those services. So, again, you have to do your due diligence in terms of assigning care to of your patients to another provider and whatnot. But yeah, so again, it really depends.
I just want to add 99% of physios I know provide exemplary care, but just don't let those few who are abusing the system tarnish the reputation of others. Right. The next question, I want to set up and deliver a physiotherapy privately in my home. What do I need to do? I could just answer this one. We do have a resource, a checklist to help physiotherapists work through. There's a number of things that they do have to have in place. Our resource is on our website, the college website, under the Standards and Resources webpage. It's called Starting a New Job. If you click on that, there's a large checklist that you can go through. I would say consider your personal safety, first of all, if you're going to be working from the home. Consider the physical space that you're going to be treating a patient with a broken ankle coming to your basement that's 2 flights down might not be appropriate either. Consider infection control. We do have a webinar on infection control. You can access lots of great resources through IPAC to help you. And then also, and importantly, you must within 30 days update the college with contact information telling us about this new private venture that you're going through, and we will update the public register with that information. There's a few other things, I don't want to labor it. It's all listed in Starting a New Job checklist. I would suggest click on it, read through it. If you've got any questions, call one of us in the advice service and we'll talk through it with you. Okay, the next question I think I'll ask Richelle if you've got any comments. It says, what if a physiotherapist treats patients in their clinic for a set fee, but then they're going to provide service in home care and they have to increase their fee? Is this a trigger for investigators? Would they target because you're using different fees?
Again, this would be something that would be very operational from carrier to carrier. Some insurance carriers may have a reasonable and customary fee that they set per visit for an initial assessment or like a subsequent visit. So depending on if this fee falls below that amount or over. So I can't really speak to if there would be a specific trigger that would be alerted if there was a difference being billed in fees.
So there might be a cap, there might be something that triggers. From the college rules, as I said earlier, you really need to be open and transparent about what your fees are, have them published. So if there's a home care and you're charging for travel time costs, make that apparent on your fee schedule that, you know, mileage or time, travel time will be charged. And again, the patient has to agree to that before they engage in care. Again, Richelle, this is another one for you, I think. Does the insurance industry provide information about why a therapist was delisted to the Therapist Regulating College? Actually, I think that's more for me. No, currently we're not getting that information. However, we do understand that the insurance company is going through quite a rigorous process, and it will depend on the carrier as well, how that process occurs. Remember, though, that the college here has a zero tolerance for bad business practices. There will, Allan, I'll let you pick up here, but there will be, if we do get a flag, if we do get notification that there's a problem with billing, there's likelihood investigators will be appointed. There could be, you'll go in front of a discipline committee, and there may be a chance that costs or revocation of certificates might be involved.
Yep, that's absolutely correct. We also, you know, we do have relationships with the insurance companies. They do often send when they do conduct their investigations, they do send to the regulatory colleges concerns of fraud and whatnot. So, so there is some information that is transferred to us. But yeah, again, what you mentioned there in terms of zero tolerance, the college takes these matters very seriously, and we do a thorough job in terms of investigating. And yeah, the penalty is fairly heavy in terms of if there's a finding of misconduct in terms of fraudulent activity for billing.
And if there is a finding, you're in front of a discipline committee, the findings will be made public on the public register, and it's forever. It'll be posted forever.
Yes, absolutely. And I'll just mention in terms of these hearings for in front of a discipline committee, they are very serious in nature. They're sort of very similar to a court proceeding, where you have a prosecutor and defense and whatnot. And most often cases, you'll probably need to require a lawyer to sort of as part of your defense. So it can be costly and expensive in addition to the penalties that might be imposed.
It's like a mini court.
Yeah, absolutely. Yep.
I'm going to ask Richelle if you could take this one. How could a patient possibly submit fake claims for their extended health benefits? What process are they using?
So I talked a little bit about this in my presentation around plan member or patient fraud. So essentially, patients have the various billing options for reimbursement. If they're collecting reimbursement on their own, so they're going to go on to their insurance company's portal. Typically, it's like a secure plan member website where they can enter the details of their claim from the receipt that they have from an appointment. So they'll enter in the type of service, the date, the amount, who the provider was. They would submit that claim, and it would be very operational as to what rules each carrier has in place to request that receipt. Typically, it's some sort of algorithm that will randomly request a receipt based on different rules that they have in place for that. So they may not be requested to provide the receipt every claim submission. So there are situations where patients may submit fake claims. They may submit, they may have one service and submit for 5 services. They may alter the amounts. So there's different things that could potentially happen, and that may be how physiotherapists are seeing patients submit claims with their credentials.
And is there any way they can follow up and check? Or I'm sure some physios will ask, how?
Typically, they would only be identified if the insurance company is validating that claim. They may receive a call asking to validate patient care. And if they haven't provided patient care, then it would be pretty evident that that's what happened. And then they could perhaps be with the college as to what the next step should be as to protecting their credentials.
Right.
Which is some of the things we've talked about today.
I just want to follow up. If there is a suspicion around automobile insurance, the one thing I could offer and help with, I do have access to providing a report for physiotherapists. They can contact me with their first, last name and registration number and ask me to run a report on any billing that's done with the automobile insurance sector, and I will provide that. I can do that the same day. I can provide that back to any billing that's been done. If you're suspicious, you may have worked somewhere or you're not quite sure how your registration number is being used, call me. We'll run that report, but only for automobile insurance. Okay, the next question that's come in is for Allan. Investigator has turned up at my clinic and directed me to provide 20 charts. Do I need to provide them? What are they looking for? Richelle, you might be able to answer this one too.
Well, from the college's perspective, if the college is conducting an investigation, the answer is yes. You are expected to cooperate. So typically what happens is a panel of the Inquiries, Complaints, and Reports Committee will appoint an investigator after a complaint has been submitted to college. So under the legislation, the Health Professions Procedural Code under the RHPA, the investigator that's appointed, they have powers to examine the practice of members, and well, they're allowed to examine the practice of members in terms of what's relevant to the investigation. So they can come in, obtain records, they can come in, interview, ask questions If you have an electronic system or security cameras, they can remove that information from your place of practice. So, and also within the legislation, you're not permitted to obstruct the investigation and from occurring. And if that does occur, the college has the powers to summons an individual to provide that information or to meet at a location to be interviewed or investigated. And then again, if that does not work, we also have the opportunity to secure a warrant through the court system. In terms of what do we look for within the charts, I think we spoke about that earlier in terms of proper record keeping. We want to ensure that the proper treatment was provided. We want to ensure that there was an assessment, there was proper diagnosis, and it was a logical treatment plan. We want to ensure that there's proper consent as well to provide to adjust the treatment plan, and if the invoices sort of coincide with the treatments, and then the observations that are made with the PT and the patient and whatnot. So we just want to ensure consistency.
So bottom line, cooperate with the college investigator.
Yeah.
Richelle, do you have anything to add? Is it similar?
Again, it can be very operational and really depends on, privacy regulations and what, forms have been kind of signed and what authorization has been provided. But similar, some of the things that Allan mentioned would be similar with the insurance industry.
And typically, a carrier, insurance carrier, they will, their client, the patient, they'll have entered into an agreement. There'll be a policy, and anyone who has extended health benefits, you realize you have signed that consent to have any health service you receive verified by the insurance carrier. So again, I think the message is for both college investigator, for the insurance investigators, you cooperate. You can verify their ability to do that, but your bottom line is cooperate. I'll take the next one, I think. Does the college provide guidelines on fees that I can charge? This is commonly asked, people phoning the practice advice service. And the answer is no. The Competition Bureau of Canada, they had concerns about the college providing guidelines on fees, and fees will depend on your physiotherapy business model. The rule that the college has is that fees cannot be excessive. What's excessive? It means that there's a range of fees for a typical practice area. If you're an outlier, you're way above those fees. That could be deemed excessive. So I own the Ontario Physiotherapy Association. If you call Amanda over at the Ontario Physiotherapy Association, she has finished a survey looking at range of fees, certain practice areas, and she might be able to share that with you as well. Can I reduce the fee per patient whose insurance only covers a portion of the cost of a service? Richelle, do you want to have a go, or should I take that one?
You can have a go, and I'll add it in.
So I'm going to say a physiotherapist can reduce a fee for patient if that's what they choose to do, but they cannot, remember going back to accuracy, they cannot produce an invoice that's false. You can't produce an invoice for $100 if the patient only gave you 60. That would be fraud. And then the patient submits it to the insurance company. If the patient, if the patient pays you $60, you've agreed to that, that's what should be on your invoice.
In addition, with the co-insurance, depending on what the coverage is, it is the patient's responsibility to be paying that difference and not writing it off essentially, or not collecting it from the patient. So based on the plan design, it may be 80%. That patient is responsible for that 20% to pay.
Yeah, so you can't submit or provide a receipt for money that wasn't received just to get out of the costs. So can I practice physiotherapy and be part owner of a practice management corporation? I'll take this one. Yes, a physiotherapist can be a part owner of a practice management corporation, but only the PT can bill for physiotherapy under their name and registration number. So remember, there's two types of corporations I'm aware of: the practice management corporation, where there's multidisciplinary, there's a physio, there's a massage therapist, there might be a chiropractor, or there's a physiotherapy, a professional corporation where it's only physiotherapists that are directors of the corporation. So I have to say though, whether you're practicing within a physiotherapy corporation or practice management corporation, my advice is to talk to a tax accountant, a tax lawyer. The practice advice team cannot give you advice on which is best for you. The college only provides a certificate for the professional corporation. So I'm wondering, time-wise, are we maybe take one more? Richelle, could you take this one? I treat patients with catastrophic injuries or they have chronic conditions. So I do have long-term therapeutic relationships with the patient. I think what this person means that their billing will be ongoing. It'll be a large amount of billing for physiotherapy services provided. So would that trigger an investigator to take a closer look at someone's practice?
Again, very operational, not necessarily. If, the provider's billing patterns, one patient is that and the rest of their patients seem to be, considered normal billing. If there's nothing out of the ordinary, they would not be triggered to provide based on one situation.
And even if they did, I'd go back to the college standards, what you said, Allan, earlier about your record keeping. If you have an assessment there, you have firm patient goals, either to maintain goals or to improve the patient's condition. If you have a treatment plan, if you have a record of attendance, if you have a good system of invoices, then you should be okay.
Exactly.
Anything else? Are we good now? Yeah, I think thank you. So we could go on and on. We have a few more questions that we could publish later in our newsletter. But as the time is running out, I just want to put a little plug. We do have a practice advice service at the college, and we do ask you to call us. You can call us between 8:30 and 5, Monday to Friday. If you have any questions about your standards, about the rules of practice, call us. We're happy to pick up. You do not have to give your name. It's an anonymous service. There's no extra fee or charge for this service, and we hope to provide a same-day service. So thank you very much for joining us today for a business practice webinar.